Good morning. May it please the Court, George Vaca on behalf of River Oaks. I'm here today asking the Court to reverse an order dismissing this matter with prejudice following a remand from this Court pursuant to its March 2016 decision. And I'd like to reserve 5 minutes for rebuttal, if I might, please. I know that two of the three of you sat on that appeal almost 3 years ago. But just to generally refresh the Court's recollection, it involved a February 2005 sinkhole claim. The claim itself was actually made in March of 2005. There was damage to one building, and then there was additional damage noticed to another 11 buildings. The claim was submitted. Initially it was denied, said that there was no sinkhole coverage at all. Then there was Judge Barbas, I believe, ordered appraisal of all of the buildings. Ultimately, Judge Sabella in 2013 entered a judgment against citizens, finding that building 19, one building was covered. He awarded fees and costs pertaining to that one building, and he awarded fees and costs pertaining to some things that didn't directly deal with the litigation of the sinkhole claim. Citizens appealed that. My client filed a cross appeal saying that the Court should have granted prejudgment interest for the other buildings and should have awarded attorney's fees.
And the only way the Court could have done that at that point is assuming that all of the evidence concerning that had been presented at the hearings, correct?
I'm sorry, that the Court...
If you're saying the Court erred in failing to grant it, it's because your position would have had to be all of the evidence concerning it was before the Court at that point.
Even if it was, and what I would like to do, so I believe all of the evidence pertaining to Mr. Dandar's fees, Mr. Wilson's fees, I don't remember the third attorney who was involved. There was a lady from St. Pete, I believe Westerman, I think is her name. I believe that testimony was that all of that stuff, all of those hours were before the Court, and then the Court then delineated which was covered and which was not covered. Yes, I agree with that, Your Honor. And so this Court then in 2016 entered its opinion, finding that the Court should award prejudgment interest on those other buildings, should award attorney's fees as it pertains to the other buildings, and should also award appellate attorney's fees for the cross appeal. Now, in response to that motion, the motion we filed in that cross appeal, citizens didn't take the position that we were seeking fees on fees for getting fees, as they've done in their brief. They simply said we were only entitled to fees on the cross appeal if we prevailed, which is what we did. This case then, both sides filed post-opinion motions. Those motions were denied on May 9th of 2016. Mandate issued June 2nd. My firm filed a motion for appellate attorney's fees on May 11th. Mr. Dandar's firm filed a motion for fees, including appellate attorney's fees, on June 6th. Of 2016, within 30 days of the issuance of the opinion, timely under the rules, timely under the case law. We then went before Judge Huey, the trial court, regarding the prejudgment interest issue. There were some disagreements about that. Ultimately, that was resolved. And then in the summer of 2017, I negotiated my law firm's appellate fees with citizens. We released citizens from our claims to fees. We specifically stated that Mr. Dandar's claims were not included in that release. And notwithstanding that, citizens then filed a motion to dismiss the claim as being moot, argued that all of the claims had been settled when they had not, which was a blatant misrepresentation of what the agreement was, and said that Mr. Dandar waived his claim to fees otherwise because he hadn't filed an affidavit. Now, the judge had entered an order on January 11th of 2017 that said, took care of the prejudgment interest and said that he would have a hearing on the attorney's fees issue if the parties couldn't agree. and Mr. Dandar was entitled to rely upon that. And if the court changed its mind and wanted an affidavit, the court certainly could have entered an order commanding Mr. Dandar to do that, but he never did.
Are there other fees that you're claiming other than Mr. Dandar's fees?
No, my fees were...
I don't mean you personally, I mean you or your client.
No, so there was only two law firms that were involved.
When you wrote the opinion the last time that the fees pertained to Building 19, I think it was reversed and said, well, there's entitlement to fees apart from 19, but I think Citizen says, well, there are no other. Everything was put in. Do you agree with that?
Even if it was, there were no additional fees awarded pertaining to the other buildings.
So are we down to talking about whether Mr. Dandar gets another fee award? Is that all we're?
Yes, that's the only thing we're here about is whether or not his firm's claim to fees was prematurely denied by the court.
Specifically the fees for March 25th and 26th, and then any appellate work, correct?
Correct. That's what we're here about.
2013, right? The March of 2013.
March 25 and 26, which was then reflected in the August 13, 2013 judgment by Judge Sabella.
Okay.
And so that's what we're here about.
Okay.
There is no question that issue was never presented before the trial court. It was simply motion to dismiss as being moot. His claim for fees had been in writing, had been timely filed. There was a hearing conducted in which he was questioned extensively about the March 25 and March 26 hearing, but nobody ever denied his entitlement to appellate fees other than by representing to the court that I had negotiated his fee, which I had attempted to do, but Citizens refused, which is why the release is so specific as to my firm's fees only. And his contention that he was still entitled to the time pertaining to the hearing that established entitlement, which occurred in March of 2013.
But their position is it didn't establish entitlement. That had already been established, and that those hearings were with respect to amount.
Well, they can say that.
They have argued it.
Well, but I can just say that...
I'm just asking you to respond to it.
Sure. They denied entitlement to fees throughout. They denied entitlement to prejudgment interest on all the other buildings. They denied entitlement to fees. Even if they consented to fees on Building 19, which I would take strong issue with, they denied anything pertaining to the other buildings. They denied that there was an entitlement to fees.
Yeah, but then there was a determination.
Right, and this is what...
River Oaks was entitled, and their position is, I understand it, and maybe I've misunderstood it, but I believe their position is that determination by the court regarding entitlement occurred before March 25th.
Okay, that's not what the judge's judgment says. The August 2013 judgment, the first sentence in it says, this cause having come before the court on March 26, 2013, on plaintiff's motion to determine entitlement to his fees. That's what the judgment says. So that's what Judge Sabella understood. That's what everybody else other than Citizens understood, was that it came before the court on their motion to entitlement to fees. And the judge determined both entitlement and amount. And he got reversed
at the March 25th hearing.
That's what this August 2000.
Okay.
That's what the August 2013 judgment says. So, at the end of the day, even if Citizens were right, there were no other fees to be determined, entitlement had been determined. At the end of the day, we still have the issue pertaining to the fees associated with the appeal in this case, the first appeal, that was never, ever considered by the court, and it should have been. So unless the court has some questions for me about that issue, that's the easy one. That's the very, very easy one. The case should be remanded for a hearing as to those fees, irrespective of trial court fees going back to 2013 and before. But since there's been no determination about that, the judge should also consider that in this case. And if the judge determines that entitlement had already been admitted or whatever, That's fine. He can make that determination, and it can be in the order that addresses all these attorney's fees. We simply are asking for the opportunity to have that hearing. So if the court has no further questions for me, I'll be seated. Thank you.
Okay, thank you.
Good morning. May it please the court, Karen Rockenbach on behalf of citizens. While it is a privilege and a pleasure to be before this court a second time this morning, we should not be here. As the Florida Supreme Court recognized over 40 years ago, all litigation must come to an end, and we ask this court to per curiam affirm this appeal. Your Honor, I want to address the entitlement issue because it's significant. Citizens in its appendix on page 588, in its response to a motion for appellate fees in 2010, said that a reasonable attorney's fee should be granted pursuant to 627.428, the fee entitlement statute. So you'll find that in the record in Citizens Appendix at page 588. As far back as 2010, entitlement was stipulated to or agreed upon. What citizens disputed, and we ended up winning in River Oaks 1, was the contingency fee multiplier. We said, Mr. Dandar, you don't have a true contingency risk multiplier contract, and this court agreed in that opinion when it reversed the 2.0 multiplier, and you expressly stated that it wasn't a contingency fee multiplier. There are a few undisputed record facts that the court will see in the record. Mr. Dandar was hired after the appraisal awards were complete, after all of the work was done on individual buildings. And so and I think...
was he hired to deal with the third party?
Yes.
Absolutely.
Yes.
The River Oaks board hired him for that?
Absolutely. There was, as this court recognized in its first opinion, there was some, for whatever reason, there was dispute between the old board and the new board, and ancillary litigation that Mr. Dandar represented them on. So when the trial judge, it wasn't Huey, it was the predecessor, when the trial judge looked at the attorney's fees, he did reduce Mr. Dandar's fees down from, I think and I apologize to the court, I don't have the exact number, maybe 150 or in that range to 125. And did not, if you'll see in that order on final judgment, it's actually an unusual title, it's called Order and Final Judgment on Plaintiff's Motions for Attorney's Fees.
Fees into 2 periods of time.
Yes.
And the total fees for those 2 periods were like 257 hours or something.
Okay.
And the court eventually awarded like
125.
Yeah.
125 at 400.
Not the full amount.
That's correct.
Right.
But when you read the final judgment, Judge Sabella does not say.
He doesn't say why.
Yeah, correct, exactly. And citizens.
They've argued, and in their briefs in the prior appeal, they've acknowledged it doesn't say why.
It doesn't.
But if he didn't, he should have.
Right, and citizens didn't make the argument at that hearing. We're going to dispute these fees because they pertain to the 12 other buildings. We didn't parse out fees, nor did Mr. Dandar's invoices parse out this work that I'm doing on this day's for Building 5, this is for Building 19.
Well, if I've understood Mr. Vaca's argument today, what he's really focused on is the fact that there was never a hearing on the motion for fees for March 25th and 26th.
I heard that as well.
Or the appellate fees. And so
Right.
I think really, we don't need to talk about the buildings
Understood.
as much as, and as far as I can see, there was never a hearing on that. And
Right.
If I'm understanding your response is, but that was all about the amount of fees, so even if there was a hearing, he wouldn't be entitled to any. But you can see there was never a hearing on that. Am I understanding that correctly?
I want to make sure we're on the
Okay,
same page.
all right.
I appreciate the court's question because for the first time I heard that we're not talking about the other buildings anymore, but that was briefed, so I didn't want to waive that
No, I
argument.
understand.
So then just dealing on those 2 dates of the fee hearing dates, the March 25th and 26th, 2013, Judge Huey, in 2017, if you fast forward, he asked Mr. Dandar at the hearing, he said, well, you had your...
Which hearing?
At the Judge Huey in 2017 says, and there's...
Is this after the remand?
Absolutely, yes, Your Honor. And he says to Mr. Dandar, and it's in the record before the court, why, you had your fee expert here. I do this all the time, Judge Huey says. We have fee hearings all the time. And you sit on the stand and you say, my time today is, approximately 8 hours, and, Get it done. It's judicial economy. You don't come back after a fee hearing and ask for fees for that fee hearing. Not only is that violative of State Farm versus Palma, because it's fees on fees, because clearly entitlement was stipulated to back in 2010, but it's also the time, and if you don't ask for it then, it's waived. And Mr. Dandar explains to Judge Huey, I don't do it that way. He just doesn't do it that way. I always file a motion afterwards. And he did, in fact, file a motion afterwards. It was 5 months after that particular hearing. It was 2 weeks after the final judgment was entered. And that final judgment that was entered on August 13, 2013, says nothing about reserving fees for those 2 days of a hearing. It's at page in the appendix number 20. It's clear. Judge Sabella, when he enters that order, is sweeping all of the attorney's fees into this order. There's no reservation. So Mr. Dandar had a couple of options. He could have moved for rehearing in front of Judge Sabella and said, oh, wait, remember I told you this is my practice. I come after the fee hearing and ask for it post-fee hearing and post-judgment. He didn't do a motion for rehearing. And when we went up on appeal before this court, that was not on the cross appeal. So we presented to the court in our briefs and today that there has been a complete and total waiver of those 2 hearing dates. So then it leaves us to discuss the appellate fee issue. The appellate fees with regard to River Oaks 1 is interesting because Mr. Dandar did not file a notice of appearance in that appeal. Mr. Vaca did file a motion for appellate attorneys pursuant to 9.400, and citizens paid him $160,000 as reflected in the record in the release. Mr. Dandar waived any right to appellate attorney's fees by those 2 failures. You either have to show up on a notice of appearance or you have to file a motion for appellate attorney's fees. I've been seeing, and perhaps it's a trend, perhaps it's pursuant to the amended rules of judicial administration, but appellate motions for fees that are due with the last brief of that party now have 2 signature lines. So it would have been Mr. Vaca and Mr. Dandar, and trial lawyers are using that type of double signature line as why I preserve my right. That wasn't done here, and there was no notice of appearance. Mr. Dandar failed to preserve his right to seek appellate attorney's fees. Mr. Vaca mentioned to the court that there was an amended motion post-appeal for appellate fees. And I looked at June. It is, I want to refer it to, because it's in the record, and it is the appellant's appendix number 35. And it is significant because it was June 14th, 2016. This court's opinion was in March, and there were post-trial motions and whatnot. If you read that amended motion for entry of post-appeal interest, costs, and fees, what Mr. Dandar filed with the court was really all about an R.J. Reynolds case, and what he was seeking to get the trial...
Interest.
Correct.
It's about interest and the statutory...
Absolutely. Yes. You have I don't know how many pages the motion is. I think it's
long.
It's 10 pages, and about 8 or 9 are dealing with the R.J. Reynolds, the motion for the interest. He did not like the calculation that citizens did with the interest. So that's what that was about. And in candor to the court, there is a scant reference on page 9 of the motion for, I'm now entitled to attorney's fees for all the buildings, the prior hearings, and the appellate proceedings. There's 0 evidence, affidavit of entitlement before this court that would grant Mr. Dandar the right to seek this, loan reference for appellate fees, and clearly it's simply not preserved. So this case must come to an end. It should not grace the doorstep of the 2nd District Court of Appeal for a 4th time, the 2nd time being the motion to enforce this court's mandate, which the court denied, and this time being the 3rd appeal. We ask that you per curiam affirm. Thank you.
Thank you. Mr. Baca?
Thank you. It's rather remarkable that I can hear a lawyer get up here and tell this court that all litigation must end and this one must end with a deprivation of due process, which occurred. Let me just point a couple things out. the response in opposition to the motion for appellate attorney's fees that was filed in this court, filed by citizens. Copies, Mr. Dan.
In River Oaks 1?
Yes, Your Honor.
Okay.
Yes. September 18, 2014, first person listed on the certificate of service is Mr. Dandar. This court's order on March 30, 2016, lists on the certificate of service Mr. Dandar. Mr. Dandar's motion before the court asked for three things: amended motion on appeal for cost, interest, and attorney's fees. And he specifically lists in his request, plaintiff is now entitled to attorney's fees for all buildings, the prior hearings, and the appellate proceedings. Okay? So this issue was squarely in front of the court. This court had granted the motion for appellate attorney's fees, and I want to correct something that Citizens has suggested to you. The fee pursuant to 627428 is rendered in favor of the insured. It's not rendered in favor of the lawyer. The lawyer is the beneficiary of it, but the statutory right is that of the insured. My client was entitled to recover statutory attorney's fees. At the hearing, I would have been required, and Mr. Dandar would be required, to give sworn testimony to establish the rate, the number of hours, and whether or not a multiplier would have been appropriate. That's what would be required to us if, in fact, there was a hearing. Citizens has cited this court not to a single rule of procedure, not to a statute, not to a case or a court order that says Mr. Dandar was required to file an affidavit for his fees. It just doesn't exist. So I agree, all cases should come to an end. They shouldn't benefit from extending this one out. There was no reason to dismiss this as moot. If for no other reason, the court could have had an evidentiary hearing with Mr. Dandar and said, what amount of time did you put into the appeal? They could have called me as a witness. They told me to save my records, I did. But that never happened, and it should happen. So I agree this case should end. It should end with an evidentiary hearing in which he gets a chance to have the client made whole, and we should be done. Thank you.
Thank you.
Vote. All right, next we've got Carpenter's Home Estates versus the estate of Mary Hurst Curry.